Our last talk is extraordinarily important, and this is an issue that I try to cover with most folks, and this has to do with legal issues. Paul Feldman is a extraordinarily experienced elder care lawyer, and it's important to be able to deal with some of the issues that Paul's going to be talking about today, having to do with financial planning and all of the legal issues that we all have to confront, despite everything that we also have to do in care of our loved ones. So, Paul, thank you very much for joining us.
Good afternoon. They always save the legal and financial readiness at the end of the day when everyone is sleepy anyway, so I hope I won't put you to sleep. Sometimes when I meet with my clients, I see their eyeballs rolling in the back of their head because you talk about so much and it's a lot to comprehend. And it's especially a lot to comprehend in just a half hour. So I will try to cover just like big topics that you should be aware of. But one thing when you're talking about this, you have to understand that state, where you live in what state, makes a difference. State laws affect how Medicaid is applied, how guardianships are administered, powers of attorney, and things like that. So it's very important to get state-specific information, and I'm a Pennsylvania lawyer, so I will basically tell you what Pennsylvania law is, and if not exactly the same as some states, it will be pretty similar. The other thing that is really very important when we talk about legal and financial readiness is that everyone may think that they're similarly situated, and someone may come into my office sometime and say, well, I don't understand why you're saying this. I just spoke to my neighbor down the street, and she has the same problem, and she was told something different. And what I tell them is that, well, I don't really know what your neighbor was told, but when you talk about this area, little things make a difference. Whether you're talking about planning for your spouse or your parent or your sibling, all those things make a difference. If you're talking about someone who has long-term care insurance versus someone who doesn't, someone has a very strong pension versus someone who doesn't, someone who has lots of resources versus someone who doesn't. So all these things make a difference. So if nothing else, you should basically hear the broad topics and then seek out individualized counsel to analyze your situation and your specific situation, and then basically get advice that's tailored to your circumstances. So when I begin with my client, I like to kind of talk about three things. The first is how you're going to make decisions when your family member becomes unable to do so themselves. You know, with FTD, it's a progressive process that eventually all individuals who suffer from it will be unable to make those decisions. How are you going to pay for the care that your family member will obviously need? And lastly, what about traditional estate planning and the transfer of wealth and wills and the normal stuff that's superimposed on this problem? Now, the other reason that this is complicated is that lots of different areas merge together when you talk about a progressive deteriorating disease. First, you have surrogate decision-making. How are you going to make decisions when your family member is unable to make them themselves? With that, you're talking about powers of attorney. You're talking about guardianships. When we talk about Medicaid planning, first you have Medicaid, you have Medicare, you have private major medical insurance, you have long-term care insurance, then you have taxes, you have both income taxes, you have death taxes, you have gift taxes, sometimes you have transfer realty tax. And then we get to the normal stuff of wills and, things like that. So it's extraordinarily complicated. So the first thing is, how are you going to make decisions when you're unable to make them yourselves? Well, we can break them down into two categories. First is an involuntary mechanism, such as guardianship. Sometimes in other states it's called conservatorship, but that's involuntary. And then the other is a voluntary. The most common one is powers of attorney. So first I'll talk about involuntary and then voluntary. And once again, that with everything that you'll hear, planning ahead is very important, whether it's on the medical side, on the social side, or on the legal or financial. So the first thing is that guardianship is generally disfavored. With all of these approaches, there are some good things about them and some bad things about them. Most of the time, I try to avoid guardianship, and that is a process by which you hire an attorney to go into court, to first hire a doctor to tell why your family member is incapacitated, unable to make decisions. Generally, your family member is there listening to all of this. Whether or not they'll remember it, a half hour, a day later is different. When they're hearing it, most times they understand what they're hearing. Then a judge will make a decision as to whether or not the person is completely incapacitated, meaning a plenary guardianship, or only a limited guardianship. And if it's even if they're incapacitated, is the person unable to make decisions concerning their personal decisions, like medical care, where they're going to live, what kind of structure they're going to be in, or financial? So one's called the guardian of the person, the other's called the guardian of the estate. Now, one of the reasons why I generally dislike that is that it's very expensive, because it could run anywhere from $3,000, and if it's complicated and it's contested, it may run into tens of thousands of dollars. So that's bad. Social aspect is very bad, because you have to have your family member in court under Pennsylvania law unless their presence would be harmed. It used to be that the standard was that they don't have to come if they wouldn't be benefited by it. Well, I don't know anyone who would be benefited by being dragged into court, but so they changed it that they have to be there. And the last reason I dislike it is that it is inflexible. Although you may be the one making decisions for your family member, if in fact your sibling disagrees with how you're handling your parent, then they could say that, hey, I want to be the one who makes the decisions. And then it's up to the judge who decides who's going to be in charge and who basically, whether it's personal or financial. So sometimes, although you may be making those decisions, a judge could say, you know what, there's a lot of money here, and I don't want to see anyone fighting. I'm going to hire a bank. I'm going to appoint a bank to be in charge. So therefore, you lose control of the finances, and then there's another expense because the bank is going to charge as well. So I generally try to avoid guardianships, but if in fact your family member is living on their own and you're trying to get mom to go into an assisted living facility and she is absolutely refusing to do so, then it's really a very good procedure, because once the individual is adjudicated, then they have no right to say where they're going to live. They have no right to say whether they're going to get divorced or whether they'll marry or whether they'll enter into a contract. They really lose all of their rights. But if in fact you have to get someone into a nursing facility, then having the guardianship is a very good thing to have. So that's generally when I try to use it, but you have to be careful as to when you will use it, because if you go into court too soon, if the person, as was shown on the stage, is only in the moderate stage, well, maybe they will be confused and be unable to make financial decisions, but they can still make medical decisions. They can still say, well, I want to live at home, use my money to hire someone so I can stay at home. And, that's a valid point. And so the judge may say, okay, I'm going to appoint someone to be guardian over the estate, but the person can retain the ability to make personal decisions. But then 6 months later, 1 year later, 2 years later, you may have to go back into court again when your family member has lost the ability to make those kind of decisions. So when to go into court is important. And if you can stay out of court, you can is best for all. And the best way to do that, and if you take away nothing else from this discussion, is the importance of a power of attorney. A power of attorney is a document between two individuals, the principal generally the person who's impaired, and their agent. And the authority that is conveyed from the principal to the agent is either as broad or as narrow as the document provides. So if you have a normal type of power of attorney, there should be 5-6 pages of legal gobbledygook that will basically have 25 different paragraphs that will say that the individual can make medical decisions, they can sell real estate, they can go into a safe deposit box, they can file your taxes, they can do anything. But you have to be careful, because if you you can name one person to act by themselves, or you can name two people to act together. If you name one person, generally it's a good idea to designate a successor. Just about 6 months ago, a client came to me that their uncle was basically being taken care of by their mother for 20 years under a power of attorney. Mother died. Brother then had no designation as a successor. So we had to go back into court to adjudicate the person incapacitated so someone can legally be involved. So a power of attorney is a very good document, and it's a very good way to express and have your principal or your parent decide who is going to be your decision maker, but it's not perfect either, because some people think, okay, I have this power of attorney, Mom, you got to go into the nursing home. And Mom can say, no way, I'm not going to go. And everyone is presumed to have capacity unless you're formally adjudicated. So just because you have this power of attorney does not mean that your family member has to comply. And as a matter of fact, if they say, I'm not going to go, then by implication, they are revoking the power of attorney. So that's not perfect either. And other times people say, you know, my mom, she keeps on going to the bank and withdrawing $200 like every other day, and I can't find the money. I'm going to have this power of attorney. And so you can say to the bank, I have the power of attorney. Do not let my mother withdraw funds. But the bank says, well, the power of attorney only allows you, in addition to your mother, to withdraw funds. It doesn't prevent someone from doing what you are now also authorized. So clearly, if you have a guardianship and you say, well, this person has been adjudicated, then they can't withdraw funds, but a power of attorney doesn't do it. So power of attorney is very important because it's inexpensive. Sometimes people will not sign these things, and they never do. Sometimes they won't sign it initially, but maybe they will 2 months later or 3 months later when they're a little bit more scared of the process and understanding that they really need this assistance. Of course, if you wait until the person doesn't recognize who you are, can't sign their name, then they don't have capacity to sign a power of attorney. So it's a fine line that you have to walk, but if you can get someone to sign it early, when you're just diagnosed, when they understand in a rational way what the problems are, then you're well ahead of the game. So surrogate decision making is very important. Next thing, how are you going to pay for health care? Well, it changes all the time, and it's difficult with this because the individual who has FDT needs different levels of care at different times. So the first, I like to break it into 3 categories: skilled care, intermediate care, and custodial care. When you're first diagnosed, you may not need any care at all, but those 3 areas, well, skilled care is usually not a problem because usually if the person is over the age of 65, they have Medicare, and Medicare generally isn't enough, and you have to have a supplemental, or sometimes nowadays you can have a managed Medicare policy, which is in the nature of an HMO. If you're under the age of 65 and you haven't yet begin receiving Social Security disability, you may probably still have a major medical policy that will cover. And unless you have some kind of really significant catastrophic illness that requires a hospitalization for months and months, which is very unusual, then having a major medical or Medicare and a supplemental or a managed Medicare policy is enough. At the other range of care is what's called custodial care, and sometimes it's called personal care or assisted care, which is, in essence, assistance with activities of daily living, meaning the person doesn't need anyone medically trained, but they do need someone to help toilet or for feeding or for dressing, things like that. And if a person needs that level of care, then either a family member provides it, or you pay for it privately, or you have a long-term care insurance policy. Now, long-term care insurance policies is not a major medical policy, and that's a newer product. And if you've already been diagnosed with a type of disease like FTD, then you become uninsurable. It's not like having a bad driving record and just paying more for your insurance. You become uninsurable. And my experience, I have found that my clients have far more flexibility when they have a long-term care policy and more choices as to dealing with the situation than those who do not. If you have a long-term care policy, it could provide for care at home, in an assisted living facility, in a nursing facility, in all three. It can provide payment for $100 a day, $125 a day. It's all different. It just affects premium. It can basically begin almost immediately, or you can have a 6-month waiting period. But having the long-term care insurance gives more flexibility to decide because you have more of a resource to kind of use to take care of your family member. But if you don't have it and your family member has already been diagnosed, can't get it. Okay, in between skilled care and custodial care is what's called intermediate care, and that's the type of care that an individual usually receives in a nursing facility. And if in fact sometimes Medicare will pay for care in a nursing facility, but only very, very limited circumstances and for limited periods of time. You have to have come from a 3-day hospital stay, be directly discharged into the care facility to receive skilled care, such as physical therapy after you've fallen and broken your hip, and then even at the most, you only get 100 days. And you don't really even get that. People say, well, at least I have 3 months to worry about it. Well, as soon as you have reached your rehabilitative potential, meaning you're not progressing or the person doesn't want to take physical therapy, then the insurance company will be very quick to say, okay, no more coverage under Medicare, you're private pay. So don't count on Medicare. So if you are in a nursing facility and you need that kind of care and 3 other criteria are met, then medical assistance or Medicaid will pay the bills. The first thing about needing intermediate care, we usually don't have to worry about that with FTD because certainly when you get into the severe category of the disease, you need that kind of care. Whether or not you have it at home with one-to-one care with a companion coming in, is up to you, and it's really a function of your finances. I caution spouses that they think that they can take care of their spouse no matter what. And sometimes, they take care of it for a long time and it kills them. So if in fact you're planning on taking care of your spouse at home, I strongly encourage you to bring in support to help you do that so that you can have some respite, you can go out, you can go shopping, you can have a little bit of a life yourself. Because if you're a caregiver 24/7, it's going to kill you. I had someone who came to me who was 40 years old. He was moving home to take care of his mother, and he was going to knock the world out. And he came back a year later. It looked like he was 20 years older. And I said, you're killing yourself. You can't do this anymore. And reluctantly, he agreed and then placed his mom into the facility. So people need intermediate care. You must be at a Medicaid certified facility. Most facilities are Medicaid certified. Whether it is or is not does not make it a good one or a bad one. I've been in some facilities that are private pay, and I wouldn't put a dog in them. There are others that are Medicaid facilities. You can eat off the floor. But it has to be Medicaid certified, because if it's not, when you run out of funds, then you have to go someplace else. The third criteria, which is really a pretty easy one to meet, is that your income must be less than the cost of care. Well, nursing homes cost $8,000 to $9,000 a month. Very few people have that kind of income, so that's taken care of. And then the last thing is that you must not have available resources. And that's a term of art because it includes some things and it excludes other things. So, and this is where it also becomes very important whether or not you're talking about one spouse taking care of another or a child taking care of a parent. Because when you have a spouse, not only do they look at the institutionalized spouse's assets, they also look at the community spouse's assets. So you're kind of regulated that way. So first, let's just talk about an individual who doesn't have a spouse. Do they have to spend down to zero? No. Do they? But they almost have to. Before you qualify for medical assistance under Pennsylvania, if your income is over $1,850 a month, you can only keep $2,400. And if your income is below $1,850 a month, you can keep $8,000. Really, the individual is allowed to have a irrevocable burial reserve account, meaning if you have money and you're going to be spending down your parents' assets and then you qualify for medical assistance and then your parent dies, then you have to come up with money somewhere to pay for the funeral. So what the government allows you to do is to take some of this money and either go to a funeral home and prearrange exactly what you want, give them the money, or you can go to a bank, open up an account that is irrevocable, and give them a reasonable sum. I generally tell my clients anywhere from $7,500 to $9,000. And then, although you put the money in and it's sitting there, it earns interest, but you can't touch it. And when your parent dies, then you can take a death certificate and get it from the funeral home with their bill of services. You present it to the bank closes out their account and makes it payable to the funeral director. Very important, because if you're going to be spending the money, you might as well put it aside for a funeral. That's really all that an incapacitated person or a person who's in a nursing home can have. Their Social Security, it will go to the nursing facility, and they get to keep $40 a month. That is it. So basically, if you need to get your new shirt and your haircut in the same month, you obviously don't have enough money for that. So that's what the institutionalized person can have. The spouse who lives at home basically can have some excluded assets. The first one, which is the most important one, is the principal residence in which the person resides. Meaning, if you have a house, if it's worth $400,000, no one will make you pay, no one will make you sell your house to pay for the care in the nursing facility. So generally that's excluded, although now they just passed under last year's Deficit Reduction Act that if your house is above either $500,000 or $750,000, depending upon which state you're in, then they include the amount above that to be an available resource. So that could be a problem. Another exempt resource is certainly an irrevocable burial reserve for the community spouse. Under Pennsylvania law, a very important exempt asset is a qualified retirement account. So if you have an IRA, a 401k, a 403b, then no matter how much is in there for the community spouse, that is exempt. But if you're talking about the institutionalized spouse, then his or hers is going to be available. So that's a big thing under Pennsylvania law, not available in a lot of other states. Then finally they say, okay, we think that the community spouse is entitled to a certain amount of income and a certain amount of assets. The amount of assets that the community spouse is generally entitled to, there's a minimum amount, generally $20,300, or half of all of the countable assets, but they cap it at a figure, and that figure is $101,650. So if you have $100,000, you can keep 50, and then 50 has to be spent. If you have 200,000, basically it's 100 and 100. If you have above that 200,000, the community spouse can still only keep $101,000, and the rest has to be spent down. So that's important. The amount of income that a community spouse is entitled to is $1,650. So if you have Social Security and you only get $650, you're entitled to keep $1,000 of your spouse's income. Even though they're in the nursing facility, you can keep $1,000. And that figure, that $1,650, is raised if you have what's called excess shelter costs, meaning that if the cost, the government expects you to have charges of at least $485 a month, and if your rent or your real estate taxes or your mortgage or your utilities, your homeowner's insurance, if that exceeds that $485, then suppose it's $685, that excess, that $200, is then added onto the $1,650, and then the person can keep $1,850, and because they only have $650 from Social Security, they can keep the rest from the institutionalized spouse's income. They also now have, and this is all very state-specific as well, that they allow individuals, if they need that extra income, then you can take some of the money that would ordinarily otherwise be spent and buy an annuity. And if you buy an annuity, it has to be for your life expectancy, and we have tables that are put out by Social Security. I just looked up one today. The person was 57 years old, and his life expectancy was 22 years. So he could buy an annuity that would pay him the $1,200 for the 22 years. However, the government says that if we're going to say that you're allowed to keep that, then you have to name the state through, in Pennsylvania, it's the Department of Public Welfare, as the beneficiary, so that if you die before that 22 years, whatever is left to pay gets paid back to the state. So those are just some of the issues that you deal with financing. Now, how about the ordinary type of medical planning? What happens if the community spouse dies first? Basically, then if the community spouse can keep $101,000, if they die first and they have the will that says, at my death, everything to my wife, at my wife's death, everything to me, and upon the death of the survivor, everything to our kids, well, here you have the spouse in your nursing home, the community spouse dies first, and then everything goes back to the individual in the nursing home. And basically, Governor Rendell would say, thank you very much. So what we generally suggest that you do is change the will of the community spouse, and then basically disinherit your spouse who's in the nursing home, so that if in fact you do predecease the the institutionalized spouse, that you've been able to protect some of your funds for your children. However, if you have that house that's in joint names, husband and wife, that titling of the house takes priority over what your will may say. Your will may say, give the house to the kids, but the deed says husband and wife. No matter what your will says, it will automatically go to your spouse. So then we generally we recommend that you transfer the house from both names into the community spouse's name. Well, if your spouse is incapacitated, and if already has been adjudicated incapacitated by a judge, you can't do that unless you ask permission from the judge. If you don't have a power of attorney, then the individual has to have capacity in order to understand that they're transferring the property. So that's why a power of attorney becomes important. Also, if you have the life insurance, if you have your retirement account that you can keep, that has a beneficiary on there. So you want to change your beneficiary because you do not want it to go back to your spouse who's in the nursing home, because then it will just be more money to be spent on nursing charges. In addition, important for income tax purposes is the fact that any of these expenses that you pay, whether for care that's brought into the home, as long as you need at least assistance with 2 activities of daily living, an assisted living facility or a nursing home, all of those expenses are considered to be medical expenses that are deductible on one's income tax return. So if your spouse is in the nursing home and you're looking for a source of how to pay for that during the spend down, I tell my clients, use the IRA first. His IRA, not yours, because yours is exempt, but his is basically countable, and you pull money out of your IRA, you get hit with income, but if you take the money and then spend it on the nursing home, you get an offsetting deduction. So that by using up his IRA first, then in essence the government's helping you a little bit, because if your spouse, after a year passes and then you the IRA is inherited by the children, they may have income. When they pull the money out, they're going to pay income taxes. So it's important to use up the institutionalized spouse's IRA first. There are other kinds of assets like that. Savings bonds. Savings bonds, you bought them years ago for $18.75, and they were initially worth $25, or they keep on going, they're worth $200. All of that accumulated interest, as soon as you cash your bond, is taxable. So if you're looking for a source to basically to use to pay for the nursing home charges, then you can use these kind of IRAs, this savings bonds. Lastly, let's talk about giving money away. One of the ways in which people used to do planning is that you had money on day one. Maybe your spouse went into the nursing home on day 2. On day 3, you can make a gift and give all your money away to your kids. And then on day 4, if you apply for medical assistance, then the government would say, hey, wasn't it just you a couple of days ago who had all these assets? And you would say, yeah, because you can't lie on the application. That's called Medicaid fraud. And sometimes I have to remind my clients of that. But the fact is that you say yes, and they say, okay, then giving money away will create a period of ineligibility. The maximum period, it used to be 3 years, and they just extended it so that it's now 5 years. Even worse, it used to be that when you gave the money away, that's when the period of ineligibility began. So that if you planned early enough, then even if your spouse was designated as or was going to have to go into a nursing facility, that you could basically give money to your kids or create a trust, pay for a period of time, the period would end, and then your spouse would be eligible for medical assistance, assuming that you had spent down. Now the government says, if you make a gift within this 5-year period, it's a blanket period of ineligibility, meaning that if you gave money away now, if it created a period of ineligibility of, say, 1 year, then they would wait to impose it until you've spent down all the money that you had to and you would otherwise qualify but for this gift, and then they would say, okay, now the 1-year period begins. So that if in fact you want to give money away, you have to be able to expect not to apply for medical assistance within a 5-year period, which, sometimes is pretty difficult because it comes on suddenly and then you can't really continue with the care. So giving monies away basically has been largely cut out, but only if you are trying to do it within shortly after the person is diagnosed. Now, you can create a trust, and people create trusts, and the community spouse, they can still get the income from it, and if they set up that trust more than 5 years ago, and they put some of their assets in there, and then they took care of their spouse at home, then the look-back period is over, that you can still get the income from it, so it's still kind of protected. It's not in your children's name, so they can't take it and pay for their kids' private tuition, and basically it's there for you. But it really is important that you start and you plan early if you're going to do that. So that's all I really have the time for. Basically, I could speak on this for like 2 hours, and I've just condensed it for like 20 minutes. So if you're kind of a bit confused, I apologize.